Hey everybody, crime and cares coming at you. Hey, I want you to look at this guy right here. His name's David Heupel. You're going to be hearing a lot of that name from me in the future because I'm investigating a case that goes back to 2002 where David was alleged to have unalived his stepfather, Bill Ricker, and attempted to unalive his mother, Barbara Ricker, who is now deceased. That was in 2002. The trial took place in 2004. But before I get into the trial of 2004, I want to take you back to when he was 14 years old to give you a little bit of context about his growing up and what he had to deal with in this household. His mother had three husbands. All have been deceased, heart attack, stroke, and this one was unalived by a knife in the back and the throat and all over the place. So here we go. When he was 14, his mother was being, let's call it what, the husband, Bill, was doing things that he shouldn't have been doing to David's mother, laying hands on her. And at 14, he took up for her, but she wanted apparently this particular relationship instead of her son, so she gave her son up. And he went into foster care. Now, in foster care, this guy right here, who at the time was 14 years old, they makes allegations that the foster care mother, who I believe is still alive, did the rape with him on numerous occasions. Dropped the G. And so that's got to mess with a kid's head. And awful, because just awful for so many reasons. So he's kind of been on his own. His mother gave him up for this Bill Ricker. Now, let's jump back to 2004 during this trial. And in 2004, the defense went after a strategy of insanity. Now, why did they do that? They did that because David had no memory. Zero. Zero plus zero equals zero. No memory of what happened. He was awakened in a camper 45 minutes from North Charleston, South Carolina, where this apparently happened. And he had little to no blood on him whatsoever, and the police woke him up. He had no idea why they were in his camper, and they read him an arrest warrant. He still didn't know about it. And even the detective, when they brought him out of the camper, said that he was out of it and didn't know what was going on. And even David was like, I don't know, what are you doing? What's happening? He was very confused. So at the time, during 2004, they went for a strategy of insanity. But the prosecution also emphasized voluntary intoxication at the time via Coca-Cola and alcohol, and arguing that did not excuse unaliving Bill and trying to unalive his mother. But what they didn't realize, and what they mentioned a little bit, I read the trial transcripts, what they mentioned a little bit was a sleeping pill called Ambien, and his Lortab, which is just a painkiller, they called it, which is basically OxyContin. It's a pain-killing drug. But at that time, this guy was on workman's comp for over a year, had surgery on his neck, and was prescribed by a doctor a combination of that Ambien and that Lortab, which is an OxyContin type that does not mix well at all. In fact, the FDA has come out with a black box warning, I believe it was in 2017, well after the 2004 conviction of him. By the way, the trial was the most ridiculous thing I've ever seen. It was a day-and-a-half trial for a unaliving trial, and that was in Charleston County. Listen, I'm not trying to redo this trial or get this guy a retrial. What I do believe, and what was not done at trial, I do think he had a defense attorney that didn't even put up a defense, literally, no defense. He tried for a a verdict after the prosecution had rested, and then he didn't get what he wanted, so he rested. Awful, absolute awful. I mean, if you're going to go for a insanity plea, then bring up some experts, bring up some people that did. But listen, aside from all that, the FDA information about the FDA and what this can do, they call it the Ambien defense sometimes, had no bearing in this particular trial because it was just a sleeping pill. It was just painkillers. That's what they thought about it in 2004, which 23 years ago really wasn't that long ago. But it's a big deal because there are studies upon studies and people upon people. There was a guy in Mecklenburg County that was had violence towards his wife and was, pew-pewing at the police, and he used the Ambien as a defense, and he was found not guilty. So these things happen quite frequently, using these drugs and combining these drugs. And what we're looking for, I think, in this one, or what he's looking for, according to his friend who's been contacting me on this one, is a PCR, which is post-conviction relief. If there's any PCR attorneys out there, contact me. I want to get you in touch with this friend who will get you in touch, I believe, with David, because I believe this case needs to be reviewed and resentenced. Because if you're going to convict in the state of South Carolina for the big M, then what you need is something called malice aforethought. And that basically is a general intent to unalive somebody, grievously bodily harm, or acting with extreme recklessness. Now, if you are under the influence of a prescribed drug and that over-medicating, like he was, then you have no idea what you were doing. He woke up in places prior to this, had no idea why he was there, what he was doing. But involuntary manslaughter is the unintentional unaliving resulting from criminal negligence. So I think there's a distinction here that wasn't covered in this particular trial in 2004. I'm going to do a podcast about this and do a little bit more in-depth on it than I am here on TikTok, but I wanted to get out there. David Heupel, we're looking for a PCR request to get this thing recategorized to either involuntary, possibly voluntary. I don't know about that. But anyway, if you're an attorney out there that works on PCRs in the state of South Carolina, Innocence Project, anything like that, give me a call. Give me a ring. Private Cask, you can message me right here. You want to follow more about David Heupel here? Like, follow, and share. Bing, bing, bing. Talk to you later. Private Cask.